Greetings, law students. I'm Jonathan Brinkerhoff, and today we're going to be covering the topic of minors' rights and disaffirming contracts. So, this topic's a bit complicated, and to start, we're going to try and break that down into pieces. First with, what is a minor exactly? So a minor, in the eyes of the law, is any person under the age of majority, which is a legal way of that saying anyone under the age of 18. And the age of majority in most states is, in fact, the age of 18. This has not always been the case. As little as 10 years ago, as a matter of fact, in the state of Mississippi, the age of majority was 21, not 18. And it's worth noting that the law may view any person who's reached the age of majority to be an adult. It doesn't necessarily mean that they can legally do whatever they please, as while you might be of the age of majority, 18 years of age, you still can't buy or purchase liquor, as an example. Now, there are exceptions to the rule. Not every person under the age of 18 is considered a minor. There's a process called emancipation, and minors can be emancipated in a couple of different ways. For example, anybody under the age of 18 who has not yet reached the age of majority, but is enlisted in the United States military, is considered to be emancipated, which is to say that they're not treated as a minor or infant in the eyes of the law. This also pertains to minors who petition the courts to become emancipated, and that's generally done with a parent or guardian approval. Now, that more or less covers what a minor is and when a minor isn't a minor. So let's look at the next part, disaffirming a contract. To disaffirm is to revoke consent once given. And that's like saying to take back a deal or acceptance of a deal. So disaffirming a contract is exactly what it sounds like. For disaffirming a contract, only minors can do this. And this is a right exclusive to minors. And that's because in the eyes of the law, a minor is viewed to lack the capacity to form contracts that are valid. A minor may disaffirm a contract at any time during their minority, before they reach the age of majority, or for a reasonable amount of time after they reach the age of majority. So if they're 17, form a contract, and 2 days after turning 18 decide to disaffirm, the courts will generally allow that. Now that we have a baseline of what the concept is that we're covering, it's time to look at this concept as it appears in law. Now, the earliest found case that we were able to define was in 1923, and it was in regards to Joseph Nations versus John Gregg. This is a bit of an interesting case. John Gregg purchased cattle from Mr. Nations, but at the time, the age of majority was 21, and John Gregg was only 18, so in the eyes of the law, he was a minor. During the branding process, Mr. Nations found out that Mr. Gregg was a minor and asked for John's father to sign, saying that he could go ahead and carry out this contract. And his father did. But shortly thereafter, John Gregg found out that some of the cattle were sick, too expensive to feed, and he couldn't keep up with the costs. So he exercised his right to disaffirm a contract. Now what's important here is that John Gregg didn't just say, well, I don't feel like paying you anymore, I'm disaffirming the contract, because that's not how it works. When a minor disaffirms a contract, they have to disaffirm it in its entirety. When they do, they effectively nullify that contract completely, which means that all parties involved have to be set back to where they were before the contract was even formed. So John Gregg gave back what cattle remained. He couldn't give back all of them because some of them were no longer in his possession to give back, and that's okay. The law allows for that. Mr. Nations tried to sue John Gregg, claiming that he was owed money for the cattle that didn't come back, and the law, or in the Circuit Court of Appeals, decided that John Gregg met his terms, disaffirmed appropriately, and as such, was released from the contract and anything ensuing. Now, more recently, we can look at TK versus Adobe Incorporated, which was in April of 2018. Now, this case was brought before the California District Court and had some uniqueness about it. Now, TK was a minor who was currently at the time living in Mexico and had utilized a free trial of Adobe software for about 14 months. At the end of that 14 months, Adobe had charged TK for a recurring subscription that he had signed up for when he initially accepted the free trial. TK disaffirmed the contract, and Adobe tried to claim that there was an arbitration clause within the terms of service when Mr. TK signed up for their product, and as such, he should have to go into arbitration. Courts found that's not the case. Again, when a minor disaffirms a contract, they disaffirm it in its entirety. That includes all the terms of services, even the arbitration clause, which was a little unique. Now, TK also tried to claim injury because the company violated their policy, charged him in spite of the fact that he disaffirmed the contract. However, Adobe Incorporated did in fact return the payments. And so the court found in favor of Adobe on that particular point. Just because a minor disaffirms a contract doesn't necessarily mean that a minor can then go after who they're doing business with if they don't like the result. The disaffirming a contract is very much a finalized thing. It nullifies the entirety of the contract. No more, no less. Now, it's clear that these particular rights afforded to minors under the law in disaffirming contracts, even as early as 1923, existed, and haven't changed too awfully much in the last 80, 90, even 100 years, which is kind of impressive. It's also worth noting that there are some contracts that involve necessities. Now, necessity is anything that is deemed necessary to survive, or will maintain the station in life, which is a fancy way of saying the things that they need to live. For these types of contracts, a minor can disaffirm, but still has to pay the bare minimum cost. That is, what the seller paid for that item. So, for example, if a minor was to buy a loaf of bread, the minor still has to pay for the loaf of bread, even if he disaffirms, but he only has to pay what the store paid for that loaf of bread, not any other fees or costs added to that. So that's more or less minors' rights in disaffirming contracts. I thank you for your attention, and please, if you have any questions, feel free to ask.